Um, the next case on the docket is Dennis F. Scott versus Central Florida Siding Pros, case 2689. It's my understanding that council has agreed in advance how to divide and allocate each side time. Is that correct?
Yes, it is, Judge.
Yes, Your Honor.
Okay. Mr. McKay, before we begin the clock for your presentation, for the benefit of the panel, would you please explain how the time is going to be allocated?
Yes, I represent the claimant Dennis Scott, and I'm going to do the initial argument for the appellant, and I'm going to try to reserve at a minimum of 3, but maybe 3 to 5 minutes of appellant time, and then Clay Meek, who represents James A. Jones Construction. He's cross-appellant, but his position and the claimant's align perfectly, so he's going to do the rebuttal, and so I'm hoping he'll have at least 3 to 5. It'd be nice if he could have 5 minutes to rebut anything. So that's how we were going to divide our time.
All right. Well, thank you. Well, Mr. McCabe, you may proceed then when you're ready.
All right. Thank you, Your Honor. And as I said, I'm Bill McCabe. I represent the claimant Dennis Scott. Now, initially, we submit the judge of compensation claims erred in concluding this claimant, who was an employee of Central Florida Siding Pros, was not covered under their policy with Norgard, who's referred to as Norgard 1 in all the briefs. There's 2 reasons for this. The first is because the Norgard policy was not properly canceled. It states right in it that if the payroll deduction or is terminated or suspended for any reason, or if you fail to maintain sufficient funds in your account to meet your obligations to us, the entire remaining unpaid balance shall then become immediately due and payable. Well, unfortunately, Central Florida, the siding company, was never given any opportunity to bring the account current. All they were given was a notice of cancellation of the policy. So we contend that a condition precedent by the insurance company, Norgard's own policy, was never met. Therefore, they couldn't terminate the policy. And I cited a mortgage foreclosure case as an example of that. So that's the first reason.
Well, counsel, so the JCC rejected that it was a condition precedent. So, how is that language linked in any way to the cancellation language that's provided in the notice?
Well, it's not in the portion where the insurance policy is canceled, but it states what happens if you get behind. You got to pay the entire unpaid balance. So it's like a acceleration clause in a mortgage. And if you're not given the opportunity to do that, how can they cancel the policy? And in fact, they wouldn't even allow this company to bring themselves current when they tried to do so after being notified of the cancellation. So, they're the insurance company. They put it in there. They need to comply with their own portions of the agreement. Now, the second reason we contend the claimant is covered by Norgard is promissory estoppel. A party is stopped from denying liability under promissory estoppel when the party makes, number 1, a promise which the promisor should reasonably expect to induce action or forbearance on the part of the promisee or a third person. Secondly, which does induce action or forbearance in reliance on the promise. And thirdly, injustice can be avoided only by the promise. The only competent evidence in this record establishes all of those elements were insurance issued by Paychex, which is Norgard's agent, to Jones, indicating that Central Florida Siding had coverage with Norgard from April 29th, 2017 to April 29th, 2018. Now, when this was issued by Paychex as agent for Norgard, they had to reasonably expect it would induce action on the part of Jones, which would be to allow Central Florida Siding on the job site.
Counsel, will you address the disclaimers set forth in the COI and what effect it had in terms of the COI?
Well, Judge, I don't think the disclaimer really has any effect because all these certificates of insurance have that little disclaimer clause in it. And so if you're going to conclude that somebody can't reasonably expect a general contractor to accept the certificate of insurance as proof that there's insurance coverage for the contractor they're going to bring on the job site, then why have certificates of insurance at all? And also, there's the testimony from Brett Siegel, he was the only expert that testified in this case, but he testified it's extremely reasonable and the standard in the industry to rely on these certificates of insurance. And there is also an administrative rule, Rule 69L-6.0321 and 2C1-7, which states these certificates of insurance are sufficient and adequate for a contractor to satisfy its obligation to obtain evidence of workers' compensation. So, I mean, there it is. It's in all of these certificates of insurance, that disclaimer clause, as far as I know.
Mr. Siegel applied the standard of the industry to the facts of this case.
Yes, he testified in this case. He was the expert witness, and there was nobody to contradict him on that. But to rule any other way,
Mr. McCabe, I've lost your sound. I don't know if others are able to hear you.
No.
I don't understand it, Judge. I really don't.
Mr. McCabe, you're back now.
Okay, this is why I'm doing it by phone, because the one yesterday, they lost me on my Zoom. So I don't know where I left off, but or where you guys couldn't hear me anymore. But my whole point is these certificates of insurance, they all have that disclaimer clause on them. They're all relied upon by general contractors. It's the standard of the industry. The rule permits it to be done. In fact, states it's okay. And so it shouldn't have any bearing on it. And the other thing I might point out, too, is these insurance companies, this Norgard never notified, nobody ever notified Jones that this policy was allegedly canceled. They also did not have that database or that way pursuant to Florida Statute 440.057 that would actually allow a general contractor to log on and see if insurance has been canceled. Nobody had any of that stuff either. So, and anyway, back to my promissory estoppel contention. The promise of insurance was relied on by Jones because he indicated that if he did not have the certificate of insurance, he would never have allowed this company to come on the job. And as I indicated previously, that's the standard of the industry. And then the third element of promissory estoppel is the only way justice can be avoided, the only way injustice can be avoided is by enforcement of the promise of the certificate of insurance. Because if you don't do that, first of all, the intent of the legislature is that construction people are covered by workers' compensation. Now, if this certificate of insurance does not bind Norgard to coverage in this particular case, you're going to have a claimant, just a hardworking person who got injured on a job and sustained an amputation below the knee to possibly have no workers' compensation coverage. You're going to have a general contractor, Jones, who relies on this certificate of insurance and was never told otherwise to possibly expose himself to considerable personal liability. And you're going to allow an insurance company who knowingly provided a false certificate of insurance through their agent and caused this entire problem to get off for scot-free. Because when they gave that certificate of insurance on February the 6th to Jones, that was after they had already sent out notice of cancellation of the policy to the signing company, and yet they never told anybody about it. Now, we submit that Criterion Leasing versus Gulf Coast Plastering, which is cited in the briefs, is on point. Now, the judge in this particular case, in rejecting the promissory estoppel argument, used the wrong test for promissory estoppel.
Also, in the Criterion case referenced by the JCC, there was nothing mentioned in that opinion about disclaimers. So I assume either that there weren't any disclaimers or they were there and none of the parties raised them. Does it make a difference here, or is Criterion distinguishable from the facts of this case because Criterion did not even mention disclaimers?
Well, but the problem with that is the Criterion case didn't say it applied because there was no disclaimer or anything like that. It just didn't even mention disclaimers, as you indicated. And to my knowledge, of course, I don't know what that certificate of insurance was in the Criterion leasing case, but to my knowledge, these disclaimers are on all of them. And as I indicated before, Mr. Stiegel indicated that it's relied on by the in the industry, and the administrative rule that we've mentioned before states that this is what you can rely on, Judge. I mean, it's just, I think the disclaimer is a complete red herring, personally, without any insurance company notifying anybody that the policy is canceled. So, but no, the Criterion case doesn't mention a disclaimer one way or the other. But I would like to get back to what I was saying before about the judge and his promissory estoppel denial. The case he cited, ironically, lists the elements that the judge relied on when he claimed promissory estoppel, but in reality, the elements are for equitable estoppel. And those elements are completely different from promissory estoppel, and there's a huge difference between equitable estoppel and promissory estoppel. Promissory estoppel can be utilized to create insurance coverage, where to refuse to do so would sanction fraud or other injustice, which would be what would happen in this case. To the contrary, equitable estoppel is really, it's just an affirmative defense, but it cannot be used to create or extend coverage. So the judge here used the completely wrong elements when he denied the claimant's promissory estoppel case. So I don't know how much time I have left, but I want to touch on point 2 and point 3 very quickly.
You have about 4 minutes and 30 seconds if you'd like to save any of that for Mr. Meek.
That's all I have left for. Okay, I'll be fast then, because the second point is whether there was a joint venture between the Central Florida Siding and the Nobles American Service, which were also insured by Norgard. And if you disagree with our argument under point 1, then claimant should be covered by Norgard under the joint venture argument. The proof of the joint venture is Timothy Nobles, the brother of Matthew, who owned the CFSP company, was on the project where the claimant got injured several times before the accident. He contacted Jones repeatedly asking for $1,000 to be paid on the job where the claimant got injured. Both Nobles brothers are on the CFSP LLC document with the state. The claimant was an employee of Noble American at the same time, really, that he was working on the Unity Tree job, as is indicated by the payroll of the NAS company. They paid this claimant $225 during the week of April 12th to April 18th, 2000.
Mr. McCabe, we've lost your sound again. So why don't we do this? I think you intended to reserve some time for Mr. Meek in any event. So I'll turn it now over to the appellees. I believe 3 attorneys plan to split the 15 minutes. So who is presenting first for the appellee's position?
I am, Your Honor.
Okay, go ahead, please.
Thank you.
Mr. Rogner.
Thank you very much, Judge. May it please the court, my name is Bill Rogner. I represent Southeast Personnel Leasing and Lyon Insurance Company. Ms. Nelson, Ms. Middleton, and I will each be splitting the 15 minutes. As for my clients, SPLI and Lyon, the claimant concedes he was not either an actual employee or a statutory employee of SPLI. The Lyon policy, by its plain terms, applies only to SPLI and its employees. Therefore, the Lyon policy does not cover this claim, and the JCC properly determined that neither SPLI nor Lyon were responsible for benefits. Now, given the length of time we have available, If the court has questions for me, I'll happily take them. And if not, I'll yield the remaining of my time to Ms. Nelson and Ms. Middleton. Thank you, Judge.
Okay, thank you.
Thank you, Your Honors. May it please the court. My name is Mary Frances Nelson, and I represent Norgard One as the carrier for Central Florida Siding Pros. Your Honors, this is a case really about failure to follow through with the business practices. My client provided Central Florida with a cancellation notice because they were not paying their insurance premiums. Central Florida failed to make them whole, so the policy was canceled. The only evidence in front of this court is that the policy was properly canceled. Central Florida Siding Pros began the job months after the certificate of insurance was issued, knowing that there was no valid workers' compensation coverage. Central Florida Siding Pros has not even participated in any of these actions because they knew that they were wrong. They knew that there was no coverage, and the JCC has struck all of their defenses. So we submit that whether or not there is a valid policy cancellation is inapplicable because those defenses would have been struck by the court for Central Florida's failure to follow through. In this situation, Mr. Jones is a general contractor who failed to verify that a certificate of insurance.
Ms. Nelson, Judge Lewis would like to ask a question.
Why shouldn't the claimant be able to make those claims in this case, even though those offenses your client's defenses were struck by the JCC?
Yes, Your Honor. The defenses for whether or not there was a valid policy cancellation would have been between Matthew Noble's Central Florida Siding Pros and Norgard. Because they did not try to participate in this matter, there's no indication that the policy was not invalid at the time of this issue. Mr. Jones knew that had received the certificate of insurance, but the certificate of insurance was issued over 2 months before the work was even to begin on the project. And it was also within days of the policy cancellation date listed on that certificate of insurance. Faced with the personal liability and a claimant who had substantial injury, Mr. Jones, as a general contractor, has failed to protect his subcontractors and anybody on his job site.
Counsel, again, on the issue of promissory estoppel, the JCC cited the T-Mobile USA Inc. case, which is the decision that was decided by the Washington Supreme Court. Even though that is not a Florida court, let me see what the court held. The court held that representation in COI as to additional insured was binding on the carrier despite the disclaimers in the COI, like we had disclaimers here. Why shouldn't we follow the Washington Supreme Court?
Yes, Your Honor. The T-Mobile case is actually slightly different. In that particular case, we were talking about an additional insured on a valid policy. So there was a policy in place. There were premiums being paid by someone. The additional insured was listed on the certificate of insurance. And the court in that case looked to the fact that there was specific language providing coverage to this additional insured. So they ruled that the general language was trumped by the specific language listed within that. And Your Honor, there's also indication within the judge's ruling in our case law briefs with the Colorado decision that has ruled that a certificate of insurance is not a promise and should not be held to be hold estoppel. And in the Colorado decision, the same situation occurred, and the courts found that these are only suggestions. There are disclaimers, and the evidence was clear that the individual knew or should have known that this was not going to guarantee coverage. There are multiple disclaimers listed on that policy. We submit
respond to the argument that there was testimony below that contractors routinely rely on these certificates of insurance. And the argument is that, or at least that was made, that expert testimony was not disputed.
Yes, Your Honor. To answer that, to respond to that question, Mr. Stiegel also indicated that these insurance certificates of insurance are quite often issued during a period where there is a pending lapse in coverage. So this is something that is rather routine. The certificates are issued, and Mr. Jones himself testified, which is expert testimony, or not expert testimony, but it's certainly testimony that would be applicable, that he knew that these certificates of insurance are not always valid. He knew that and his testimony was that they're not worth the paper that they're written on. In this situation, we were dealing with a certificate that was issued months before the actual work was to be performed. And in order to, if you were to continue and require the carrier to provide coverage for this company, you would actually be sanctioning fraud by requiring Norgard to provide coverage. In this case, Central Florida knew they didn't have insurance. They showed up on the job site. They didn't pay their premiums. And by being able to obtain workers' compensation coverage for this particular accident would actually sanction fraud on behalf of an employer who fails to file his policy premiums.
Counsel, one other question. Appellants have argued below that coverage is necessary to avoid injustice here. What remedies, if any, exist for this injured worker if we are to affirm the JCC? And also respond generally to the injustice argument that's made below.
Okay, thank you, Your Honor. My position is that Mr. Jones, as the general contractor, has remedies. Number one, the general contractor should have had policy coverage for situations such as this. His own workers' compensation policy with the Southeastern Personnel and Lion directed him to secure workers' compensation coverage for these uninsured individuals. The remedy for Mr. Jones in situations such as this is governed by Chapter 440, where it states that the general contractor may subsequently go after these uninsured subs. So he can go after Central Florida Siding Pros and the owner of that company. But the injustice is having an insurance company who canceled a policy for non-payment of premium to have to provide coverage for something when the general contractor very well could have and should have been holding workers' compensation policies for instances such as this. And I want to point out, Mr. McCabe had referenced the Criterion leasing case. And in that particular situation, that was a case that was over 20 years ago. We don't know what, if any, disclaimers were listed on that certificate of insurance. But what we do know is that there was actually a valid policy in place. The only distinction for that one was that an individual, an employee of the insured company, was not covered individually. So at least there was some type of policy in place, effective policy in place, and coverage in place. Thank you, Your Honor.
Thank you. Ms. Middleton.
Yes, thank you, Your Honor. May it please the court. My name is Jody Middleton. I represent Norgard 2 and Nobles American Services in this matter. The key to this case with regard to my client, and most telling is, which was accepted by the court, is the testimony of Mr. Jones himself. Mr. Jones testified that he had obtained the Unity Tree project. He contracted with Central Florida Siding Pros and Matthew Nobles for the job. He had never met the owner of Nobles American Services prior to the accident. I believe they may have interacted by phone or in years past, but he had not interacted with them. He had not contracted with Nobles American Services. He had not invoiced Nobles American Services. In fact, Jones invoiced Central Florida Siding Pros for the Unity Tree project. He went about obtaining the certificate of insurance for Central Florida Siding Pros, and on and on. Nothing from Mr. Jones' testimony or any evidence in the court suggests that Nobles American Services was in any way tied to the Unity Tree project. what the claimant has argued is that my client essentially gets bootstrapped into this case at all because of either a joint venture or dual employment. So how this came about, in my opinion, is that Nobles American Services is owned by a gentleman named Timothy Nobles. So you have two brothers who each own a separate siding company, each obtain their own separate work, and each run their business. There was some testimony that Timothy Nobles sometimes may have been at a job site where his brother's company was doing the job, or he worked on some of the jobs that his brother's company was doing. The only testimony that we have available to us is that the two companies were never working for or on a job site at the same time. So the key distinction in this case is that we essentially have four entities. We have Nobles American Services, we have Timothy Nobles, we have Matthew Nobles, and we also have Central Florida Siding Pros. And, you know, there's often situations where people wear different hats, if you will. So in this situation, the claimant worked for Nobles American Services doing Hardie siding. He worked for a job in New Smyrna Beach weeks prior to his injury. The payroll records from paychecks from Nobles American Services verifies he was paid by the owner, Timothy Nobles, for his work in New Smyrna Beach. He was paid $150 a day. So based on the payroll records we have, it appears that he maybe worked for them through about April 14th or so. The claimant's testimony was, I finished my work on New Smyrna job, took a couple days off, then went to work on the Unity Tree project. That project was sole and separate and distinctly the project for Central Florida Siding Pros, as testified to Jones. So you have Mr. Scott taking off the hat of Nobles American Services, essentially, and putting on the hat of Central Florida Siding Pros and going to a new job where he does the same type of work. Now, with regard to the legal arguments of the claimant in terms of joint venture, the first element of establishing joint venture is we have to have had some sort of contract that was formed between the two alleged companies of the joint venture. There's no testimony that I was able to find in the record that the two companies ever had a binding contract or agreement to jointly work on any project.
Was it the case that they all had the same employees generally? And there were some kickbacks between the two? Help me understand that testimony.
Yes, Your Honor. So from the testimony that we have employees that install Hardie Siding, is the brand of the siding. And if Matt is bidding the job, he's bidding it under his own company, which is CFSP. If Tim is bidding the job, the job is contracted through Nobles American Services. They both had separate workers' comp coverage. They both had separate jobs. But according to the testimony, Tim would go work on his brother's jobs with the group of guys who did Hardie Siding. Then they would pull from the same pool of employees and say, okay, now it's Tim's turn. I have a job with Nobles American Services, and it sounds like the guys and maybe even the brothers went to do the work for that company. But there's no evidence that the two companies were ever working jointly, obtaining contracts jointly, or doing any of the work jointly. Now, there's some dispute as to whether or not there was profits received by both brothers for any individual job. But from the testimony that we have, it says, from Mr. Nobles, Timothy Nobles, was that his pay on any given job would be a portion of the project. So look, I'll help you as Timothy Nobles, the individual, on this project, and my pay results in however much you make off the job. But the distinction here is that Timothy Nobles is separate and apart from Nobles American Services. He wasn't always one and the same. And there's no evidence that Timothy Nobles, as the owner of Nobles American Services, was ever in any way contracted or linked or in any way joined with the Unity Tree project. In this specific situation, joint venture fails because there's absolutely zero testimony in the record with regard to any potential losses. There's no testimony to suggest the two companies would share losses on any given project if they were to occur. There's no testimony that the two companies ever worked jointly on a contract, period. It's pure speculation by Mr. Scott as to what he heard or didn't hear. As I'm running out of time, Your Honors, I would ask that the court affirm the lower court's order in denying benefits for Mr. Scott with regard to Nobles American Services and Guard 2.
Thank you. Mr. Meek, you have about 3 minutes and 11 seconds left. Please proceed.
Thank you, Your Honor. May it please the court. Rather than go into a summary, I'd like to address the justice's questions that have been advanced so far here today. Specifically, Justice Lewis asked a question about the disclaimers within the certificate of insurance and what bearing that might have on this particular case. I think Mr. McCabe addressed it very well as far as whether or not that disclaimer can or cannot override Florida law or can or cannot change Florida practices. But another very important point I want to make sure is made clear is the disclaimer on that certificate of insurance does not even apply to the misrepresentation contained within the certificate of insurance. The certificate of insurance that was issued by Norgard 1 says there is a policy currently in effect through April or the end of April. And the disclaimer says, if something changes, we'll let you know, but if we don't, not our fault. Too bad. The fact is, the moment that certificate was issued, they knew that policy was canceled as of February. That disclaimer that they tried to use to avoid Florida law, to avoid the Florida Administrative Code, and to place this burden improperly on other parties, does not even apply to the certificate of insurance that they issued. Second, Justice Lewis, I thought you asked a very good question dealing with the extension of Washington law to Florida. And I think if the panel will read the Judge of Compensation Claims' order, I think it is very clear that the Judge of Compensation Claims actually thought promissory estoppel should apply. That is why he cited those cases from the other jurisdictions. The error that the Judge of Compensation Claims made in this case was believing that Florida law did not already have promissory estoppel applicable to this matter. There are only 3 cases on this point that have been handed down by this court. There is Criterion Leasing, there is Atlantic Masonry, and then there is the case cited by Appali, Centimark Corporation versus Gonzalez, which if you actually read it, supports the position that both Scott and Jones are advancing in this case. In the Centimark case, the panel said that it was not reasonable to rely upon the certificate of insurance that had been issued because the certificate of insurance on its face showed that it applied to an employer that was not present on the job site. That would equate in this case if Norgard had issued a certificate of insurance that says, hey, we've got coverage for ABC Construction through April, and then Jones relied upon it and said, well, they've got a certificate for ABC Construction. I know that Central Florida Siding Pros isn't ABC Construction, but I'm going to rely on it. That would be akin to this case. Centimark clearly means and clearly stands for the proposition. I apologize, I have gone over my time. May I briefly conclude, Your Honor?
You may briefly conclude.
Thank you. Just to address Your Honor's questioning about the injustice or the effect of what has happened in this matter. Obviously, the claimant does not get benefits. Mr. Jones is called a general contractor. He's a single guy that just does a little bit of construction on the side. He's in his 70s. And in the bigger picture, the injustice is if certificates of insurance can't be relied upon, what I am telling all of my clients that contact me is it's worthless to you. And you have to assume that you cannot do business under these things if they're allowed to disclaim away what they claim to be telling you. Thank you all for your time and your consideration.
Thank you, counsel. Thank you to all the attorneys for your presentations today. I hope you have a wonderful afternoon. The court will stand in recess.